You walk into a grocery store in Hawaii, you have a concealed carry permit, your gun is holstered, you're legal. Or are you? Under Hawaii law, even with a permit, you cannot carry a gun on private property that is open to the public unless the owner posts a sign saying firearms are welcome. No sign? You're committing a crime. This is called the vampire rule. Like a vampire, you need an invitation before you can enter. And on January 20th, 2026, the Supreme Court heard oral arguments about whether this law is constitutional. The case is Wolford versus Lopez. And based on those oral arguments, Hawaii is about to lose. Badly. The justices were skeptical. They grilled Hawaii's lawyer. They asked how this is any different from requiring permission to exercise free speech or practice religion on private property. Hawaii had no good answers. And gun rights advocates are celebrating because the oral arguments signal a massive victory is coming. But the decision won't drop until June. And when it does, it could strike down similar laws in other states. You need to understand what just happened at the Supreme Court and what it means for the future of carry rights on private property. Quick question before we continue. Are you subscribed yet? Because what I am about to reveal is real-time analysis of Supreme Court oral arguments from 2 months ago that signal Hawaii as vampire rule is doomed. The justices' questions tell us everything we need to know about how they'll rule. And that ruling will affect carry laws in multiple states. Hit that subscribe button right now because when the decision comes down in June, you need to understand what it means immediately. Here's what happened and why it matters. Hawaii passed a law in 2023 in response to the Supreme Court's Bruin decision. Bruin struck down New York's May issue carry permit system. After Bruin, Hawaii had to issue permits to qualified applicants. But Hawaii didn't want to, so they passed a law creating a default ban on carrying in most places. The law says you cannot carry a firearm on private property that's open to the public unless the property owner explicitly authorizes it. That means grocery stores, gas stations, restaurants, shopping malls, anywhere the public can go. Unless there's a sign saying guns are allowed, you can't carry. And guess what? Almost no businesses post those signs. Why would they? Posting a guns welcome sign in Hawaii would be political suicide. So the effect of the law is a de facto ban on carrying almost everywhere. Gun rights groups immediately sued. The lead plaintiff is Wolford, a Hawaii resident with a carry permit. He sued Lopez, who was the chief of police at the time. The case went to federal court. The district court struck down the law. The court said Hawaii can't require permission to exercise a constitutional right on private property open to the public. But Hawaii appealed to the Ninth Circuit, and the Ninth Circuit reversed. The Ninth Circuit said private property owners have rights too. They can decide whether to allow guns on their property, and the state can create a default rule requiring permission. Wolford appealed to the Supreme Court. And on January 20th, 2026, the court heard oral arguments. For over 2 hours, the justices questioned both sides, and the tone was clear. Hawaii is in trouble. Let me break down what happened because the oral arguments are a roadmap to the decision. Hawaii's lawyer opened by arguing that private property rights are paramount. Property owners have the right to exclude people with guns from their property. The state is just creating a default rule. If owners want to allow guns, they can post signs. This respects property rights while protecting public safety. Chief Justice Roberts interrupted. He said, "But you're not protecting property rights. You're overriding them. Under your law, a property owner who wants to allow guns has to post a sign. What if the owner doesn't care? What if the owner is fine with people carrying but does not want to make a political statement by posting a sign? Your law forces them to choose. That's not respecting property rights. That's dictating them." Hawaii's lawyer tried to pivot. He said the default rule makes sense because most property owners probably don't want guns. Roberts cut him off. He said, "You're speculating about what property owners want, and you're making them all speak by posting signs. That's a First Amendment problem, not just a Second Amendment problem." Justice Thomas jumped in. He asked, "Where's the historical support for this? Did governments in the 18th or 19th centuries require property owners to post signs inviting people to carry guns?" Hawaii's lawyer admitted there are no exact historical analogs. Thomas said, "Then you lose under Bruin. It's that simple. This law has no historical foundation. How can it be constitutional?" Justice Alito asked about the practical effects. He said, "Under your law, someone with a carry permit in Hawaii can't go to a grocery store, a gas station, or a mall without committing a crime. Unless those businesses post signs, which they won't, so the permit is worthless." Hawaii's lawyer said people can carry in other places. Alito said, "Like where? Their own home? That's not bearing arms, that's keeping them. Bruin protects the right to carry in public. Your law makes that impossible." Justice Kavanaugh asked the toughest question. He said, "Imagine a state passes a law saying you need explicit permission from property owners to hand out religious pamphlets on their property, even if the property is a shopping center open to the public. Would that be constitutional?" Hawaii's lawyer hesitated. He said that's different because of the First Amendment. Kavanaugh said, why is the Second Amendment different? Both are constitutional rights. Why can you require permission for one but not the other? Hawaii's lawyer didn't have a good answer. He said gun rights are more dangerous. Kavanaugh said, that's not a legal argument. That's a policy argument. And Bruin says policy arguments don't count. You need historical tradition. Do you have it? If you're finding this helpful so far, imagine what you'll learn in my next video where I break down which other states have vampire rule laws and how the Wolford decision will affect them. Subscribe right now so you don't miss it. Now, let's talk about Wolford's lawyer's argument because it was devastating. The lawyer opened by saying, Hawaii has inverted property rights. Historically, property owners decide who can enter and what they can bring. The default is freedom. If an owner wants to ban guns, they can post a sign. That's how it works everywhere else. But Hawaii flipped it. Now the default is ban, and owners have to post a sign to allow guns. That's not respecting property rights. That's overriding them, and it violates the Second Amendment. Historically, people carried guns in public places, markets, town squares, inns, shops. Now, there was no requirement to get permission from every property owner. You had a right to bear arms in public, period. Hawaii's law eliminates that right by making every property a prohibited zone unless the owner affirmatively allows guns. That has no historical support. Justice Jackson asked, but doesn't a property owner have the right to exclude guns from their property? Wolford's lawyer said absolutely, but the owner has to exercise that right. The state can't exercise it for them by creating a default ban. If a property owner wants to ban guns, they can post a sign saying no guns. That's their choice. But Hawaii is making the choice for them. That's unconstitutional. Justice Barrett asked about sensitive places. She said, Bruin recognized that governments can ban guns in sensitive places like schools and courthouses. Doesn't that support Hawaii's law? Wolford's lawyer said, no, because sensitive places are defined by the government's interest in the property. Schools and courthouses are government-run and serve public functions where safety is paramount. But a grocery store or gas station isn't a sensitive place. It's a normal commercial property. The government has no greater interest in a private grocery store than in any other private property. And historically, people carried guns in commercial establishments without issue. Justice Gorsuch asked about the signs. He said, under Hawaii's law, property owners who want to allow guns have to post signs. But posting a pro-gun sign in Hawaii is politically controversial. Some owners might support gun rights, but not want to attract attention or backlash. Your law forces them to speak. Isn't that a First Amendment violation? Wolford's lawyer said yes, it's a compelled speech issue. The state is forcing property owners to take a public stance on guns. That violates the First Amendment. So this law has both Second Amendment and First Amendment problems. Now, quick legal note. This is educational information based on oral arguments, not legal advice. The Supreme Court hasn't ruled yet. Hawaii's law is still in effect. If you're in Hawaii with a carry permit, you cannot carry on private property open to the public without explicit permission. Do not violate the law based on oral arguments. Wait for the actual decision. Consult with a Hawaii firearms attorney. Now let's talk about what the oral arguments tell us. Based on the questions and tone, here's my prediction. The court will strike down Hawaii's law. The vote will probably be 6-3, with the conservative justices in the majority. Chief Justice Roberts, Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh, and Justice Barrett all seemed hostile to Hawaii's position. They questioned the historical basis. They questioned the practical effects. They compared it to other constitutional rights. All signals they'll vote against Hawaii. Justice Sotomayor, Justice Kagan, and Justice Jackson seemed more sympathetic to Hawaii, but even they asked tough questions. So my prediction is 6-3, possibly 7-2 if one of the liberal justices joins the majority. The opinion will be strongly worded. The court will say states cannot create default bans on carrying in public places. Property owners have rights. But the state can't override those rights by forcing owners to post signs. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about what this means in practice. If the court strikes down Hawaii's vampire rule, Hawaii will have to allow carry permit holders to carry on private property open to the public by default. Property owners who don't want guns can post no gun signs. But the default flips. Freedom is the default, not ban. This is huge for Hawaii gun owners. Permits will actually be useful. You can carry to the grocery store, the gas station, the mall. You don't need to see a guns welcome sign. You just carry unless there's a no gun sign. And most places won't post signs. So you'll be able to carry almost everywhere. But the implications go beyond Hawaii. Other states have similar laws. California has restrictions on carrying in private businesses without permission. New York has a similar scheme. If the court strikes down Hawaii's law, those laws fall too. We could see a nationwide expansion of carry rights on private property. Gun control groups are terrified. They're saying the court is ignoring property rights. But gun rights groups are celebrating. They're saying the court is finally respecting both property rights and gun rights correctly. Let me give you real-world examples. Imagine a guy named John. John lives in Honolulu. He has a carry permit. Under the current law, John can't carry at his local grocery store because there's no guns welcome sign. After Wolford, John can carry unless the store posts a no gun sign. The store doesn't post one. John carries legally. He feels safer. That's the change. Now imagine a woman named Lisa. Lisa owns a small business in Hawaii. She doesn't care if customers carry guns. But under the current law, if she wants to allow it, she has to post a guns welcome sign. Lisa doesn't want to. She doesn't want the controversy. So she doesn't post anything. After Wolford, Lisa doesn't have to post anything. Customers can carry by default. Unless Lisa posts a no-gun sign, which she won't because she doesn't care. Lisa's property rights are respected. She doesn't have to speak. That's the freedom. Now imagine a guy named Tom. Tom owns a restaurant in Hawaii. He's strongly anti-gun. He doesn't want guns in his restaurant. Under the current law, Tom doesn't have to do anything. Guns are banned by default. After Wolford, Tom has to post a no-gun sign if he wants to ban them. Tom does so. His property rights are respected. He can ban guns. But he has to exercise that right. The state doesn't do it for him. That's how property rights should work. This information could literally expand your carry rights if you live in Hawaii or another state with a vampire rule. Subscribe now because my next video will explain exactly what to do the day after the Wolford decision drops to start carrying legally in places you couldn't before. Hit that subscribe button. Now let's talk about the timeline. The decision will come down in June 2026. The court announces decisions on Mondays and Thursdays. We're watching for the announcement. When it drops, it will be binding immediately. Hawaii will have to comply. Gun owners will be able to carry on private property by default. And other states with similar laws will have to change them or face lawsuits. Now let's talk about what happens if Hawaii loses. Will they comply or will they try to work around the decision? My prediction is Hawaii will try to minimize the damage. They'll probably argue that the court's decision only applies to the specific law challenged. They'll try to pass new laws with slightly different language that achieve the same result. Gun rights groups will have to stay vigilant. They'll have to sue again if Hawaii plays games. But the bottom line is this. Once the Supreme Court says you have a right to carry on private property open to the public by default, that's the law, states can't ignore it. They can fight at the margins. But they can't recreate the vampire rule. Let me give you another scenario. Imagine a gun owner named Sarah. Sarah lives in California. California has a law similar to Hawaii's. After Wolford, Sarah's gun rights group sues California. They cite Wolford. They argue California's law is identical to Hawaii's. The court agrees. California's law is struck down. Sarah can now carry in places she couldn't before. That's the domino effect. Wolford doesn't just change Hawaii, it changes every state with a similar law. Now let's talk about the dissent. When the decision comes out, there will be a dissent. Probably Justice Sotomayor writing, joined by Justice Kagan. The dissent will argue that property rights and public safety justify Hawaii's law. Private property owners should be able to create gun-free zones, and the state can facilitate that with a default rule. The dissent will say the majority is ignoring the real-world dangers of guns in public places, but the dissent will lose. The majority will respond that property rights cut both ways. Owners who want to ban guns can, but the state can't ban guns for them. And public safety is not a sufficient justification under Bruin. You need historical tradition. Hawaii doesn't have it. Now, let's talk about what gun owners should do. If you live in Hawaii, wait for the decision. Don't start carrying in prohibited places based on oral arguments. The law is still in effect. When the decision comes down, read it carefully. Understand what it says and what it doesn't say. Then start exercising your rights. Carry where you're allowed. If a business posts a no-gun sign, respect it. That's their property right. But if there's no sign, you can carry. If you live in another state with a vampire rule, start preparing your lawsuit now. Contact gun rights organizations. They're looking for plaintiffs. You could be the person who brings down your state's law. It takes courage, but it's worth it. And if you live in a state without these laws, support gun rights groups that are fighting these battles. Donate, volunteer, spread the word. These fights are expensive, and they need resources. Look, I spend hours every week watching oral arguments, reading transcripts, and analyzing Supreme Court tea leaves, so you know what's coming before the decision drops. The least you can do is subscribe to make sure you never miss the analysis when Wolford is decided. Subscribe right now. And if you found this helpful, share it with every gun owner in Hawaii and every gun owner in states with vampire rules. They need to know their rights are about to expand. Spread the word. Remember, this is educational information based on Supreme Court oral arguments in Wolford versus Lopez. It is not legal advice for your specific situation. Hawaii's law is still in effect. The court hasn't ruled yet. Do not violate the law based on oral arguments. Always consult with a firearms attorney in your state before carrying in places where you are unsure of the law. Stay informed, watch for the decision in June, and understand that this ruling could be one of the biggest Second Amendment victories in years. The vampire rule is dying, and carry rights are expanding. This is the future, and we're winning.